Testing Justice Douglas, Justice Connors, Justice Mead, Chief Justice, Justice Horton, Justice Lawrence.
Testing one of the lavaliers. Testing the other lavalier.
be seated. Good morning. The first matter before the court is State of Maine versus Trevor DeRozier. This is Penobscot 23429. We are being streamed live on the web, and I would ask counsel to identify yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
For the appellant, Trevor DeRozier.
Mark Rucci for the appellee, State of Maine.
Thank you. Mr. Peterson, if you're ready to proceed, we'd be happy to hear your argument.
Thank you, Your Honor. Good morning. Trevor DeRozier's constitutionally protected right to a fair trial was violated in this case because the prosecutor crossed the line between delivering hard blows at closing argument and foul ones. Specifically, the most stark example of this, or I would call it plain and obvious example of this prosecutorial error, is when the prosecutor commented upon Mr. DeRozier's exercising of his Fourth Amendment right to be free from warrantless searches and seizure, and begged the question to the jury, what should we make of that? What should we make of the fact that Mr. DeRozier did not allow Trooper Cotton into his house and more or less said, get a warrant? And Your Honors, this is commenting directly upon the invocation of a constitutional right, is plain error, and there's a reasonable probability that the jury went back into that deliberation room and asked that question to themselves, perhaps others, and then came to the conclusion the prosecutor was trying to draw, that Mr. DeRozier didn't let law enforcement into his trailer because he had something to hide, because he knew what he was doing was wrong. This, coupled with some of the other examples of prosecutorial error, such as calling Mr. DeRozier a liar, referring to him as devious 4 times, together resulted in an unfair trial to Mr. DeRozier in a case where the state failed to present any direct evidence that the alleged victim and Mr. DeRozier were not spouses, which is an element of the crime that must be proven beyond a reasonable doubt. And with that, I'd be happy to answer any questions.
Why don't we take that last one first? A number of us have been trial judges, and in that instance, the prosecutor will typically say something to a young victim. This may be a silly question, but are you married to the defendant? And everybody sort of wonders about that. And I think there's an inference that can be drawn sometimes based upon age. But in this case, we have a trail of instant messages in which the defendant says to her, "How old are you?" 15. "Oh my gosh, that's hard, and your parents are going to shoot me." A lot of things are totally inconsistent with being married, plus the fact it was, a 4-week relationship. Why can't the jury simply look at those facts, which are strongly indicative of no marital relationship, and rely upon that without the victim having to say, "No, we're not married"?
Well, Your Honor, I agree. It's an easy question to ask that presents direct evidence, and it could have been asked in this case, but it wasn't. And it's true, circumstantial evidence alone can satisfy that element beyond a reasonable doubt. But in this case, it's pure speculation for the jury to make that leap. Sure, this was the evidence of the record was that this was a short-lived relationship. And I take your point, Your Honor. Conventional beliefs and societal norms, they would come to show that these two may not be married, but we're not just dealing with jib-jab at a coffee shop. This is a courtroom where the state must prove beyond a reasonable doubt.
Well, and if we watch the tape, he's saying over and over how happy he is he did not have sex with her. Doesn't that kind of infer perhaps they're not married?
Well, I would disagree with that, Your Honor, respectfully, and I think there are other cases where just because there's no sex doesn't mean somebody's not married. I mean, I don't think that's enough to prove beyond a reasonable doubt that they're not married, especially in a short-lived relationship. This is about, the possibility, which the state acknowledges the possibility, that the two people eloped in a different state, perhaps. And
Okay, they eloped, and then he's still unhappy. He's still happy that they're not having sex. Added with all the other information, the jury doesn't leave its logic at the door when it goes into the jury room, correct?
That's correct, Your Honor. And as I conceded, societal norms would say that that's maybe the case, but...
So is there anything in the record? I mean, a reasonable doubt is a doubt based on a reason. Now, there was no direct testimony, but what would be what would the reasonable doubt in the jury's mind be based on here?
That there was never testified that they were not married, and it's not the
But
defendant's burden.
given this record, which the jury has to deal with, what's the basis for a reasonable doubt?
Your Honor, there were conversations in those messages where they talked about marriage and its prospect of wanting to be married. And I agree that can be interpreted various different ways.
Well, doesn't
What-
that exactly lead to the conclusion that they weren't married?
Well, it could lead to the other conclusion is that they were seeking the prospect of marriage, Your Honor. And again, this is not the defendant's burden of proving. The defendant
But it's not the
doesn't-
prospect of marriage that would be problematic in this circumstance. And what about the fact that apparently, according to the Facebook messaging, they met for the first time on May 7th? And at least the record suggests that they first had sex either on May 7th or early on the morning of May 8th. There would have been a time to get a marriage license.
Your Honor, I'm not sure that the record reflects that the first time they had sex was May 7th. There's not the evidence about when those encounters before May 21st happened. There's no specific time that this actually happened. So I'm not sure I agree with that, Your Honor.
But it was certainly within a very short period of time after they are first meeting each other online.
I agree, Your Honor.
And that's on May 7th, and then it all culminates May 21st. So we really only have 2 weeks in there.
Yes, Your Honor. And Your Honor, that again, as the state concedes, that this could have happened. There's a possibility it happened, and it's not the defendant's burden to show that it did happen. It's
I don't want to take all our time on this because you've got some other points that we
Thank
really
you.
need to get to. I'll wrap up maybe with this. Are you advocating for a rule of law that says if the state doesn't ask that question, that ipso facto destroys the case?
I'm not, Your Honor. This is a on-the-record type case. I agree that circumstantial evidence alone can prove it, but I don't believe on this record that that's made sense.
So let's talk about vouching. Obviously, it would be structural error for the district attorney to say, in my opinion, this guy's a no-good liar and you should make the same decision. But by the same token, you agree, I think you agree, that the state can draw out facts, that prior inconsistent statements, other things along that line, and ask the jury to make a conclusion from that. Why do you think the state went over the line in this matter for vouching?
Where the state goes over the line is toward the end of the rebuttal on closing argument, Your Honor. When the state goes through its 3 witnesses that was put on during their case in chief, goes through them, and then at the end of going through their testimony, talks about credibility, believability, who's telling the truth, that's important. And it says, makes the phrase, we suggest to you, and then says, facts are what you hear on the witness stand. Fiction is what he told Trooper Cotton that night. And in that way, the prosecutor is assigning truth and believability and facts, which is the jury's job, to the witnesses in a case where the defendant does not testify. And so the prosecutor is saying they told the truth, those are facts. What you heard on that camera, body camera, that's fiction, which is another word for lie.
But what he said on that recording there obviously was not true in several instances. I don't remember the exact language, but there's no one here. Oh, wait a minute, she went out the window. Those were undeniably false statements. The prosecutor can say that, right?
Your Honor, yes, they can say that there are inconsistencies here. There was somebody in that trailer. But a big issue here is that Mr. DeRosiers is saying, as the court's articulated already, is that he was saying, I'm so glad I did not have sex with her, and used some other language to say that. But he made that statement, which is the theory of his defense, is that they didn't have a sexual act. And then the prosecutor's getting up there and saying, that's fiction. Everything you heard him tell Trooper that night is fiction. And that includes that statement in his defense, which is that the sexual conduct didn't actually happen. So it's not just that, so that's a big part of what the statement he makes, and the prosecutor is assigning fiction
But
to that
isn't he
statement.
doing that in the context of summarizing the evidence and telling the jury he suggests it's for them to decide?
Your Honor, he does say that over and
Yes,
over again.
he does, doesn't he?
And Your Honor, he also says the line, and that's based on the evidence, and it's repeated throughout. But just because you say that line doesn't insulate the error.
Well, let's get back to what you started with, which is commenting on the do you have a search warrant. Now, this is a federal claim. It's not based on the Maine Constitution. So we look at the federal law, and therefore there's a harmless error measure that we found. It's not structural. So why isn't that harmless error, assuming it is an error?
It's a comment upon the invocation of a constitutional right, which this court has said has no real relevance in a case, and that it's
Chapman versus California says you use a harmless error standard. So why isn't it harmless, given all the other overwhelming evidence in this case about what happened here?
The overwhelming evidence, Your Honor, is not dispositive on the issue about whether or not there was prosecutorial error that resulted in...
It was an isolated point. The policeman didn't go into the trailer. He didn't violate the Fourth Amendment. So why wouldn't we apply harmless error here?
Your Honor, the police officer did... It wasn't just an isolated comment. Even if it was just an isolated comment, I would still say it's harmless error. But this was something that was talked about in testimony.
I think you're trying to say it's not harmless.
Well, excuse me, Your Honor, I misspoke. But this was something that was mentioned in testimony, too. Trooper Cotton testified about something about question. Now, when he said something, you need a warrant, and you said something about exigent circumstances, yes, what do you mean by that? And then Trooper Cotton talks about exigent circumstances. He later testifies that he used exigent circumstances, and Mr. DeRosiers had referenced that the search warrant a couple of times, and then circles back to it in closing argument in order to try and make the jury infer guilt based upon the fact that he told him to go get a warrant, which is exercising his constitutional right. And we don't want to affect people.
I understand it's error. Why isn't it harmless error?
Your Honor, it's not. It's because I think State v. Glover is a case that talks about this issue, albeit in a different context.
That was plain error as an evidentiary matter,
as an
correct?
Evidentiary issue, yes, Your Honor. But I think some of the reasoning.
It was not isolated in Glover. It was throughout talking about the DNA samples, right? So it is a different context.
But I think the reasoning and the rationale in the law court's holding in that case, it still is relevant. The defendant's refusal to consent to a search in some circumstances tends to prove consciousness of guilt. However, its minimal probative value will always be substantially outweiged by the danger of unfair prejudice.
Which is a 403 analysis, which is pretty liberally evaluated by us, correct?
Yes, Your Honor, but there's a reasonable, the law court found in that case that there was a reasonable probability that the state's argument about his failure to consent to a warrantless search persuaded the jury to disbelieve his testimony, or in this case, proceeded to believe that DeRosiers had something to hide and that he
Well, it's pretty clear from the audio that, I mean, what happened right after he said, "Do you have a search warrant?" is he could hear that there was someone in there, and it progressed without, there could have been exigent circumstances in that context. So isn't this a little different than the situation in Glover?
May I answer, Your Honor? I believe
it's yellow.
It was
you can
red
answer.
for a second.
Just fast.
You got 30 seconds.
Yes, Your Honor, it's different. That was an evidentiary issue in Glover. This is not. This is a prosecutorial error issue. And the issue here is not just on that one statement, but the court looks at the cumulative error of all of these prosecutorial errors.
All of which were unpreserved, correct?
Yes, Your Honor, that is correct. Thank you.
Mr. Rucci?
Madam Chief Justice, and may it please the court. Jurors are instructed to use their common sense. They are instructed that circumstantial evidence can be just as persuasive and compelling as direct evidence. Respectfully, this court should bear those instructions in mind and conclude that the jury was absolutely justified in determining that DeRosiers and the victim in this case were unmarried, irrespective of the lack of direct evidence in the form of the question that Justice Meade posed, even in lack of that evidence, that direct evidence. This court has never required direct evidence to establish a fact that could be established beyond a reasonable doubt by circumstantial evidence, and it should not do so here, where there is no reasonable doubt on the record that these two parties were unmarried. Further, none of the prosecutor's remarks during closing or rebuttal, either taken in isolation or in toto, rise to the level of obvious error affecting substantial rights. The prosecutor's comments were forceful, but were related to the evidence in this case. When he said the defendant was a liar in that moment, it was based upon video evidence where his deception was discovered in real time. When he said that the statute at issue was designed to protect younger people, he was correct based upon the legislative history and based again upon common sense. When he said the victim had no motive to lie and entreated the jury to find that she had no motive to lie, it was responsive to the defendant's closing argument, putting motive in issue. The state's closing, like its prosecution, was forceful, but it was not violative of the defendant's due process rights, and the verdict of the trial court should be affirmed, and I'm happy to take any questions.
Well, you kind of missed in that litany of why there wasn't any error, the commenting on the do you have a search warrant? That was error, wasn't it?
I would, so I'm prepared to concede that that comment should not have been made, yes, that was error. Your Honor, two things. And maybe the first doesn't really bear on this court's analysis, but unlike in Glover, there's a real question as to whether this officer actually needed a warrant on the basis of the exigency that was, I would submit clear on the record. So that's one thing. The other thing is this court can pretty easily conclude, from my perspective, that that error, whatever it was harmless in context. This was one passing comment where the officer of the court, where District Attorney Almy said, what's the implication of that? It was never again referenced anywhere else.
Let me stop you right there.
Sure.
What is the implication that is drawn from the fact that a person exercises a constitutional right? What do we draw from that?
Well, Your Honor, the implication, I think, in most contexts would be, I'd admit, as Attorney Peterson said, would be that he's hiding something. Here, the jury doesn't need to imply anything, because within a minute of...
But if that's the implication, i.e. that if you exercise a constitutional right, and commenting implies that, or that implies that you're guilty or that you're hiding something, isn't that exactly why it's critical that there not be a comment? You have that right.
I do believe that in some instances the defendant has that right. I'm not necessarily willing to concede here that he had the right to demand a warrant on the facts before the jury, but I also would suggest and would assert to this court that
but if
the jury, sorry.
I'm sorry for interrupting, but I just want to stop you at that point. If the implication that the state's attorney is asking the jury to draw is he must be hiding something because he must be guilty because he exercised this right here, doesn't the analysis stop right there, that that's an improper inference to draw from the exercise of a constitutional right? It sounds like you're trying to sort of say there's a continuum here of how prejudicial it is.
Yeah, I'm not willing to concede that the implication is he must be guilty.
That he's hiding something. I mean, that's what he's saying.
What I'm willing to concede is that he's saying, well, he doesn't want them to come into this apartment because this girl is here. And the jury learned that immediately. So let's say...
So that sounds like a harmless error analysis.
Yes, that's what I'm saying. And imagine a world in which Attorney Almy doesn't say that. The jury heard on the record the defendant say, you need a warrant. And then they heard, in the video, you need a warrant. And then they heard less than, I think, a minute later, the officer go, hey, come out from under the bed. I mean... It was there regardless. That evidence was before the jury regardless. We have one isolated comment on it.
Can I go to the issue about the age? I mean, I understand and the idea that can certainly, the failure of evidence in this case, of direct evidence that they're not married. I understand that certainly that can be proven by circumstantial evidence, but isn't it a great deal more fraught when the victim is 15 than when the victim is, say, 10 or 8 or something like that, to try to rely on circumstantial evidence?
Absolutely, but it is more fraught, Your Honor. I mean, it's easy.
And you're wishing that
My
question
life would
was
be a lot
asked.
easier if attorney, yes, my life would be a lot easier if Attorney Almy had asked that awkward question, which I do have experience myself asking. But on the basis of this record, which, by the way, in the transcript in page 246, I think it is, there was a direct comment by the victim about them having sex the first time that they met, which, I mean, the jury could easily conclude, when would they have had time to get married? She's saying, we met for the first time in person, we had sex. They went to a chapel sometime, at night after she snuck out, got married in secret, and then had sexual intercourse that first night. By the way, I would suggest that's unreasonable. And then couple that with the Facebook messages where they continue to talk about, I need to meet your parents, I'm out here looking for a wife, and then you come along. It is clear on this record that these parties were unmarried.
On the issue of the comment on the search warrant, do you agree that the defendant invoked his constitutional right?
Based on my memory of the record, yes. The question is whether that invocation itself was, not lawful or unlawful, but whether he actually had the right to require.
If someone invokes their right, why does it matter whether, as a matter of law, they did or didn't have the right? I'm not sure I follow.
Well, I think in the Miranda context, it would matter if someone said, I'm invoking. People say it all the time where they said he didn't read me my rights, and sometimes that's required, and sometimes it's not required. So
That's not the invocation. The invocation is, I'm not going to answer questions in the Miranda context. Right?
Sure, yeah.
I'm going to remain silent, and you certainly can't comment on a choice to remain silent.
Absolutely not. That's Lovejoy.
Well, but if the justification for the invocation was at issue, then we'd have a trial in front of the jury on whether the state needed a search warrant or not, which I don't think we want to go there.
That's probably fair, Your Honor. I think what this court can respectfully rest its hat on is the fact that this is harmless error. And it is a federal claim. There's no preserved state claim here. It's harmless error.
Well, we've said that the closer a prosecutorial comment comes to commenting on the exercise of a constitutional right, that has a direct bearing on whether the error was harmless. Said that in a recent case, Judkins, State versus Judkins.
Yes, and familiar with that case as well, it having come out of my county, Your Honor. But in that, in that case, we've got, that case had to deal with clear and repeated comments, much like in Glover. In Glover, the real issue was that was a staple of the prosecutor's case. The fact that this person would not give up their DNA without a warrant. That became a central focus. Why wouldn't he do that? Why wouldn't he give his DNA? Here, while it's not dispositive, I think that's State versus White, I put a footnote somewhere in my brief, where whether the error is harmless under the federal standard, I believe, is dispositive, whether it would have any impact on the proceeding. Here, I would suggest that you can find that it would not have.
There don't seem to be additional questions. Thank you.
Thank you.
Mr. Peterson, I think you
Thank you, Your Honor.
reserve 2 minutes.
Thank you. We don't piecemeal prosecutorial error when we're looking at cumulative error. We don't just, this is not just an isolated incident where there's a reference upon the invocation of a Fourth Amendment right. I'd ask the court to look at the context of what happens before this statement is made, beginning at transcript 413, where this is where the prosecutor comments upon the character of DeRozier. He says, we don't just identify who he is, we identify the type of person he is. Proceeds to call him devious 4 times, proceeds to call him a liar.
There's a tape that shows that he's consistently saying things that instantly turn out not to be true. So is it a big stretch to say that the evidence suggests that he's being devious?
Your Honor, well, prosecutors aren't, there's case law that says the prosecutors aren't supposed to be commenting on the character of a defendant or calling them a liar. And I think that's what the prosecutor was doing here, was we called Mr. DeRosiers a liar and then proceeded to say, and in addition to being a liar, he had something to hide. He knew what he was doing is wrong, and so
And based on that tape, is there really much room for the jury to conclude otherwise in any event?
Your Honor, there's that. I would tell the court again that he says, "I'm so glad I didn't have sex with her." And in closing argument, the defense's theory is that sexual contact never happened. And so when you look at that statement, the prosecutor multiple times is saying he's a liar the whole time he's talking to Trooper Cotton. It's all fiction, including that statement where he said we didn't have sex, which is what the theory of the defense was.
Is there a distinction between prosecutors saying that on that night what he did there, that was devious, as opposed to saying he is devious?
I think there is, Your Honor. When he's saying he's devious, he's surreptitiously taking this girl and being devious, very devious, and talking about this defendant as though he's some kind of has like these master plans, is the way he was talking about it, and was very savvy is another word he kept using to describe the defendant. All of that is injecting a personal opinion upon Mr. DeRosiers, which is error. Thank you.
Thank you. Well, thank you, counsel, for your argument in this case. As is our usual practice, we'll take the matter under advisement and issue a decision in due course.
All right.
The matter before the court is Black Bear Hydro Partners versus the Board of Environmental Protection et al. And we are being streamed live on the web in this case, both by video and audio. This is Kennebec 23491. I think I neglected to say the docket number. If I would ask counsel to identify yourselves by saying your names for the record together with the party you represent, starting with the appellant.
Thank you. Matt Warner for Black Bear Hydro Partners.
Robert Martin on behalf of Respondent Appellee Board of Environmental Protection.
Bill Kennedy for Respondent Downey Salmon Federation.
2 days in a row. All right. Counsel, if you're ready to proceed, Mr. Warner would be happy to hear from you.
Yeah, thank you. Good morning. May it please the court. The question
I see you've opted for the green light immediately, so.
Yeah, I always feel like if you all have questions, I'm happy to take them.
All right, let's jump right into it. Let's start with, I think, a preliminary issue here. This is an ADB appeal from the denial of a permit, correct?
Correct.
And that denial was predicated on 3 independent grounds, and you are challenging one of the 3, which is the Leonard Lake aspect of it. Am I correct so far?
That's correct, Your Honor.
So the fact that the other 2 independent grounds by themselves produce the same outcome, inevitably, which is that there's still a denial of a permit, we can't offer any relief in the setting of this thing, no matter whether we adopt one position or another. That denial is still out there. Is this case justiciable?
Well, this was an issue before the trial court on motions to dismiss, and the trial court did deny the motions to dismiss on those grounds.
But we're not bound by that, are we?
You're, of course, not bound by that, Your Honor. And the rationale there, which could and should still apply, is that this case it would be more efficient. Basically, it boils down to more efficient to decide this question
There's
now.
no exception for more efficient, is there?
Well, it's judicial efficiency and efficiency of the parties and of the administrative process.
Again, that's not one of our recognized exceptions so that we can hear this, is it?
I think we said in the Brunswick case, a case is moot and therefore not justiciable if there are insufficient practical effects flowing from the resolution of litigation to justify the application of judicial resources.
And thank you, Your Honor. And I suppose the practical effects here, aside from simply the efficiency of it, is that if I may take a step back and just explain the posture of the relicensing proceeding, there were 3 grounds denied. One of them relates to Lake Leonard. The other 2 relate to an upstream lake, Graham Lake, and are unrelated to the reasons here. Depending how Lake Leonard is classified, whether it's GPA or B, will could dramatically affect the nature of the relicensing proposal and what Black Bear Hydro Partners would do in order to get this project relicensed and meet state water quality standards. Were this appeal dismissed now without this question being decided, Black Bear would essentially be taking a guess at what should be done.
Well, they wouldn't be taking a guess because the board has already told you what they think.
That's true, but Black Bear, of course, we feel the plain language of the statute dictates otherwise.
So you're contemplating reapplying, correct?
Yeah, the intention is to reapply.
So this is an adjudication. You're not going to win this adjudication because of the other 2 grounds. It's over. Then you say, I'd really like to have an answer about what this statute means. Isn't that what deck actions are for?
Yes, however, in this case,
is anything stopping you from filing? Why did you file an ADB appeal if all you're asking for is an interpretation of the statute so you know whether you have to spend $1 billion in your relicensing?
Well, we did file a deck action along with the ADB appeal.
But it wasn't on this ground.
And in the, I would just say, Your Honor, that none of the parties to this case are challenging this appeal.
I get the sense that everybody would like to have this question answered.
Yeah, correct.
The department would like to have it answered, some clarity to move forward. But as I said, we're on an ADB from a denial. But Would you like to jump into the merits of the case?
I would just, thank you very much. I think on one last point, though, is just that, and to be completely frank, I don't know if your honors will decide this weighs for or against my point, but I also think this question of how these two statutes interact has much broader implications than just this river. It affects whether or not Section 467 should be read to specifically require, and what that means. Great ponds to be called out in a certain way affects every impoundment.
I agree. This is a very sweeping, broad issue that affects a lot of things. And you're correct, there is tension in the language there, and you've done a great job of boiling it down to the issue of the word specifically as provided in 465A.
And I think I can boil down our argument to the point that if you need to look at Section 467, you need to look at things like history or geography, or you need to draw inferences, or you think that 467 is ambiguous as to whether or not Lake Leonard should have been included.
So let me back up for 1 minute. Do you concede that if we find statutory language ambiguous, we would defer to the board's interpretation?
I do, but I don't concede that the outcome in this case is ambiguous.
So you have to, in order to prevail, if you get past the justiciability issue, you'd have to say it's unambiguous.
It is unambiguous that Lake Leonard is not specifically provided as a classification other than GPA in Section 467.
Well, at least in theory, the classification of Leonard Lake is the equivalent of a rulemaking by the department, I think. And that could be challenged independently of a permitting proceeding, could it not?
Well, no, because Section 465A says that all great ponds default to GPA unless this other statute, 467, specifically provides otherwise. So regardless of rulemaking, the legislature has said if it's a great pond, which Lake Leonard is.
But you're saying that Leonard Lake should default to the Class GPA rather than be categorized as a Class B water body.
That's correct, Justice Horton, and that's because nowhere in Section 467 does it specifically provide.
But so
otherwise,
aren't you really challenging the department's classification of Leonard Lake as opposed to the denial of your permit in substance?
Yeah, I suppose that's true in practical effect. Though I guess I take issue with the idea that the department...
It's still an interpretation, the department's interpretation of a statute to so classify Leonard Lake as opposed to a rule. But nonetheless, they're interpreting the statute to say that Leonard Lake is Class B and not GPA.
Yeah, the department has taken the opportunity to interpret the statute in this way and decide that Leonard Lake should be Class B, and whether you cage that as something akin to a rule or a administrative opinion, either way, the department doesn't have the authority to act contrary to what the legislature has decided.
In the 4 minutes we have remaining, I'd like to take you right to laser focus to the issue. And correct me if I'm wrong. I believe it's your argument that if we go to Section 467 sub 18, that it basically gives a range, a geographical range of basically the extension of the Union River, that is Class B there. And you point out that in the other sections of, other subsections of 467, sometimes the impoundments are specifically excluded or specifically included. And this one here doesn't include any specifically designated portions of the river. And therefore, because the Leonard Lake is not included, that it should default back to the GPA. Is that correct?
Almost.
And
I think that the nuance I would put on that is that 22 times we point out in our brief the statute describes a stretch of river that includes an impoundment, and it says including the impoundments. That obviously is a specific provision. Other times the statute does something else. If you read 467 in a vacuum, I think there's no way to dispute that it would be ambiguous. You'd have to resort to things like geography and statutory history, and this court would be bound to defer to the findings of the agency that administers the statute. However, because the phrase specifically provided in section 465A is not ambiguous, specifically provided as a plain
But then
meaning
when you
word.
go to 18 sub A1, it says, from the outlet of Graham Lake to Tidewater. And there's no question that Leonard Lake is between the outlet of Graham Lake and Tidewater, correct?
That's certainly true, but the opening paragraph of section 467 says that this section applies to surface waters, quote, that are not classified as lakes or ponds. So if we were looking at section 467 standing alone, that opening paragraph saying the things we're going to list next are the things that are not lakes and ponds, and this is how they're classified, but we know that Lake Leonard is in fact a pond because of this other statute, that would be ambiguous. But that section 465A solves that problem for us and gets rid of any ambiguity because, again, there has to be a specific provision, and by definition, a specific provision should be apparent from the face of the statute. If you have to resort to things like geography and understanding what the legislature went through to craft the statute, by definition.
But if we go to section 18A, describing this continuum, this uninterrupted line of water, it's as if the statute says, okay, all letters between A and G. And you say, well, they didn't specifically say D, so it isn't really included in that continuum. Is that oversimplifying the issue before the court?
I think if the opening paragraph said this statute classifies every other letter in the alphabet, and then you had all statutes between A and D, because again, this section 465 explicitly, or 467 explicitly eliminates ponds from the things it's classifying, unless it says otherwise. And there's no mention of Lake Leonard or the pond in this stretch of river.
Well, you're essentially arguing that if section 467 is ambiguous as to how a water body is classified, then 465 unambiguously says treated as GPA.
Yes, that is our
So
argument.
the bottom line is we're supposed to look at legislative intent. Does the legislature ever intend to be ambiguous?
No, but the legislature does intend to say here's a default presumption, and if we don't say otherwise.
But why shouldn't we have to identify, clarify, because they were trying to find legislative intent?
I don't think you need to say the legislature intended to be ambiguous. I think you need to say the legislature didn't specifically provide for this thing, and therefore, no matter what you could glean from other factors, you shouldn't even go there because it's unambiguous that it's not specifically provided. Thank you.
Thank you. Mr. Martin.
Good morning, and may it please the court. I'd like to start with the issue of whether or not this court can reach the question of Leonard Lake's classification. We believe the court can proceed with this appeal, and the board welcomes a decision on the merits based on the very unique circumstances here. Namely, where we have a Rule 80C appeal challenging only one of three independent bases for denial of an application, where the trial court denied motions to dismiss raising justiciability concerns and no party has appealed that decision, where appellant has represented that it will be filing a new application for the same stretch of waters, and where there's a purely legal question of what water quality standards will apply in that stretch, and then finally, where all parties agree that the question should be reached now. So based on those unique circumstances, we think the court can reach the merits here. And with respect to the merits, this case starts and ends with the plain language of the statute. Title 38 MRS 467-18 classifies the geographic area of the Union River, quote, from the outlet of Graham Lake to the Tidewater as Class B. Black Bear does not dispute that Leonard Lake falls within those clearly delineated geographic boundaries. Moreover, the word Tidewater unmistakably or precisely describes, as the Superior Court put it, the geographic feature that marks the outer limit of the Class B riverine area. Leonard Lake is impounded by a dam that's located at the Tidewater, and therefore the statute unambiguously classifies Leonard Lake as Class B. And the statutory structure further bolsters this plain language. Looking at classifications on a segment-by-segment basis, as the board did here, is the correct way to read the statute, given the different wording the legislature used within each section to classify stretches of water. In the section at issue here, the legislature defined around bodies of water it wanted to exclude from riverine classifications, such as Graham Lake. However, it does no such thing with respect to Leonard Lake. So for this reason, the court should affirm the board's plain language reading of the
I see you're
statute.
green lighted, so why don't we retrace our steps back to the justiciability issue. As you pointed out, this is an appeal from an administrative decision, ADC appeal. A permit was denied upon 3 separate bases. Even if we embrace and adopt everything the appellant is urging here, that denial still stands. We have not produced any practical effect flowing from the disposition of this case. Now, you have an advisory opinion maybe going forward that would help in future matters, but as far as this case goes, it's really moot. There's nothing we can do that will undo that permit.
Well, again, Your Honor, I mean, we moved to dismiss on that basis before the Superior Court, but based on the factors that I've previously mentioned in my opening.
But are those factors that we recognize as factors to say, okay, if these things are present, we're going to issue what is in essence an advisory opinion?
So I think those factors with respect to justiciability really go to this court's prudential considerations and how it looks at whether or not it can hear a case before it. We know that this issue is going to come before the court again. No parties raising the argument here.
What's stopping them from, we deny the ADC appeal, so it's the adjudication is over. They have to go reapply. It's going to cost them X amount of money if the classification is what you say. Why can't they just file a declaratory judgment action?
They may be able to do that. We don't think this particular case is a declaratory judgment action. I mean, it's clear that the legal issue here is arising from a final agency action,
Well,
which falls
now
under
they're
ADC.
saying, I want an interpretation of the statute. We obviously have a case in controversy. We concede on those other 2 bases, and so now it's going to cost me $1 gazillion. Please interpret the statute for me.
Your Honor, that may be an option for appellants, but again, as we've mentioned in our brief, we think the court can reach this issue now.
I'm struggling what the principle is then. You've identified some factors that you said make this unique. It's a Rule 80C appeal challenging one ground. Okay, every Rule 80C appeal. Trial court denied the motion to dismiss. Hate to say this, but sometimes we disagree with the trial court. I think that's part of our role. That it's a legal question. We get a lot of those. And that all parties agree. I'm not sure why that should have any impact. And the only other thing you said is that they're going to file a new application at some point. Well, okay. How does that make it more justiciable, or why any less advisory? I mean, I suppose you can say that that's kind of coming up into the idea of it's an issue that is, going to reoccur, but it's not capable of evading review. It's very reviewable if they file again.
Right. I think all of the issues that we're highlighting really go to the practical nature of the court's ability to consider this now. And again, those are recognized in this court's.
But really, does it come down to anything other than you all want us to do it?
Your Honor, again, we certainly want you to do it. We welcome the court to provide clarity on this legal issue.
Well, there's also an interesting question of, yes, our standing is generally prudential, so we can do what we want, except there's the APA. And if you establish, here's what you have to do under a statute in order to have standing to appeal, then doesn't it become jurisdictional and we have no choice?
That's a great point, Your Honor. With respect to standing and ADC, a party has to be aggrieved by an agency decision. And here, where an entity is challenging a denial of their application, that appears to satisfy that hurdle of showing that they're aggrieved. But there are other justiciability doctrines.
They're not aggrieved at the bottom line because they're conceding that they didn't meet 2 of the things they had to meet, so they're conceding essentially that it shouldn't have been granted. So how are they aggrieved?
I think at a base level, Your Honor, it's an ADC challenging the denial of of an application, and that's,
Except
you
it's
know,
not
that's a
really
final
challenging
agency
the
action.
denial. That's the problem. They're really conceding the denial on a couple of the grounds.
In the 3 minutes you have left, I'd really like to hear you talk about the merits. And in this case, there's tension between these statutes. But the department has designated its own interpretation of them. To what level of deference should we defer to the departments of their interpretation of this particular statute?
Well, as an initial matter, we think the statute is unambiguous. The statutes are unambiguous, Section 465A and
But do you acknowledge some
467.
tension between them? There's a bold statement saying all all great ponds are GPA.
Yeah, I don't know that I'd characterize it as a tension between them. I think you have to look at them together to answer the legal question before the court. And Section 465 says something has to be specifically provided in 467.
But
that
it also
turns us
goes
to
down, not to interrupt, I'm sorry for interrupting. Subsection 1 says, Class GPA is the sole classification of both great ponds of natural lakes and ponds less. So, boom, it's a broad statement right there. And then you go to 467, and it seems to go back to the introductory language that takes it into an exception. I would like to hear the department's rationale and its interpretation.
Sure. So we think that starting with the plain language, whether something's specifically provided in 467, the plain language definition of specifically provided is with precision, or as Black Bear concedes in their brief, by unmistakable reference. We think by defining clear geographic boundaries and using precise language like the tidewater, which isn't used everywhere in the statute, where the
Can I just stop you for 1 second? So I think they even concede that if you just focus on that language is specific. But what do you do with the prefatory language in Section 467 that says all surface waters lying within the boundaries of state in river basins that are not classified as lakes or ponds? And isn't this classified as a lake or pond? And so isn't how is this grabbing into it, the lakes or ponds within the river basin, if it's not specified?
Well, Your Honor, when you look at the statute in its entirety, that is the opening language, but the statute then goes on to classify several things as GPA explicitly, or include or exclude.
And there are many of them that talk specifically about impoundments or lakes within the river basin. This does not.
It doesn't, but it uses a similar mechanism to what's used in other situations where the legislature within that segment is defining around bodies of water it wants to exclude. Here, Graham Lake is a Class GPA water body, and it starts the classification from the outlet of Graham Lake. And it does no such thing, I see my time's up.
Finish your sentence.
It does no such thing with respect to Leonard Lake. So for that reason, we think it's Class B.
Thank you.
Thank you.
Mr. Kennedy?
Good morning, Your Honors. If I may, I'd like to quickly touch on justiciability. There is case law that we've cited and the AG's office has cited that I believe answers some of the questions you've raised. On page 18, footnote 16 of DSF's brief, and footnote 7 on pages 26 to 27 of the AG's brief, this court's prior decisions in Hurricane Island versus Town of Vinyl Haven and Levanta v. City of Waterville very plainly recognize that this court has authority to transform an
We do,
ADB
but
or
in
ADC.
Hurricane Island, for example, the part of the problem was that the administrative appeal did not lie. Isn't that part of the problem? And here, clearly ADC is a mechanism for appealing the denial of the permit. The problem here is different. It's that it was denied on other grounds, and therefore there's not necessarily a live controversy.
Well, Your Honor, I think the focus, and this is also seen in other authority from this court, Annable versus Board of Environmental Protection, which is 507 A2D 592, and Parker v. Department of Inland Fisheries and Wildlife, which is 2024 ME 22. Both of those cases squarely recognize that declaratory judgment action is proper when there is a controversy about the interpretation of a statute.
But not if there's a permitting, not if there's an adjudicative permitting decision
Right.
that we have said is to be reviewed exclusively under Rule 80C if it's from a state agency. That's the problem, is that, and regardless of how we decide the Leonard Lake classification question, I assume your client and the department would be looking for the court to affirm the denial of the permit. And so even if we were to disagree with the department, we'd be affirming the denial. So our analysis would be complete surplusage to the judgment.
Well, I think the law and this court's own decision, I'd respectfully disagree that it limits it so much. I mean, Labonte, the plain language is there that we are not elevating form over substance.
We have certainly said that declaratory judgment is available in certain contexts. For example, anticipatory challenges to involving interpretation of statutes. For rulemaking, if a person aggrieved by a particular administrative agency rule wishes to challenge the validity of the rule apart from any permitting decision, that person should bring a declaratory judgment action. And this strikes me as a rule, as fundamentally a rule of the department interpreting Section 467.
Well, Your Honor, in Annabelle, and I'd asked the court to look at this, the challenge was to a non-binding advisory opinion. I mean, I think it shows the breadth of the declaratory judgment action.
And I think that's why Justice Connors was asking that question. The problem is this isn't coming to us that way. It is coming to us on appeal of a permit that, frankly, both your client and the department think we should affirm the denial of the permit. That's the problem.
Well, and I think Hurricane Island and Labonte, I mean, it's kind of a two-step
Declaratory
analysis.
judgments actions are, like Justice Horton said, anticipatory. So this case goes away, the permit gets denied, then they file an anticipatory declaratory judgment action saying, we got to do this again, but it's going to cost us $1 billion, so please give us an interpretation. That's a different procedural context. And isn't that what declaratory judgment actions are there for?
Well, frankly, Your Honor, I think, again, there's a concern about elevating form over substance. There's no dispute that this question is going to come back.
It might be jurisdictional. Do we really have a choice here?
Under Labonte and Hurricane Island, I think this court has plainly recognized that it does have authority to do this. This is a justiciable live controversy. No benefit is served by doing this. There would be a waste of judicial resources. There's ongoing harm to the river, to the people
But
who
it's a
use the
live
rivers.
controversy between the parties, but it's not a live controversy in the context in which it's presented to us, because all we can do is affirm or vacate the denial of the permit, and nobody is suggesting we should do anything other than affirm the denial of the permit.
I would respectfully argue that under 80B, which is Hurricane Island and Labonte, it's the same process where you're either affirming or denying.
This is an 80C. There's a statute, the APA. Doesn't that make it jurisdictional?
I don't think it makes a difference. What we're trying to do is to not elevate form over substance.
You're trying to get an advisory opinion for something that's going to happen down the road.
This court's own authority has recognized that on non-binding advisory opinions, it has authority to decide those questions when it's properly before it, which is this case.
Thank you.
Thank you.
Mr. Warner, you reserved 3 minutes, I believe.
Yes, thank you. I think it's possible to find that Black Bear was aggrieved in the sense that that word is used in the APA by this decision, because though the permit will be denied either way, there are concrete costs and consequences that flow to the company.
If we were to define that as being aggrieved, doesn't that then open up every single ADC appeal as being permissible to seek essentially an advisory?
Well, I think it's distinct in the sense that in this case there is an intent. Black Bear must reapply if it wants to relicense this hydropower project. There's an intent to reapply. This question will certainly be heard again, and
can
frankly,
be adjudicated in that process very nicely, can't it?
It will, though that process with being adjudicated later instead of now could involve 2 more applications for water quality certification. If Black Bear needs to reapply following this court's decision to dismiss this case, it has this difficult choice whether it decides that the department's wrong and sticks to its original relicensing proposal, goes through this process again, applies to the department, appeals to the board, appeals to Superior Court, ends up back in this court in due course. And then this
Or,
court addresses the
having
question.
remediated the other two things perhaps that the department has identified, you then have a declaratory judgment action saying, you know, we think the department's
That would be our hope.
interpretation is wrong.
That would be our hope. And I would also want to point out that the APA does allow courts to remand with instructions to modify as opposed to rehearing questions, and I think that dovetails nicely with the definition of aggrieved I just offered this court. Okay, thank you.
Thank you. Well, thank you, everybody, for your arguments in this case. As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. Thank you.
All rise.
seated. And good morning. The matter before the court is Jennifer Owen versus Town and Country Federal Credit Union, BCD 23442. We are being streamed live on the web by both video and audio. I would ask counsel who are arguing to introduce themselves by saying their names for the record, starting and together with the party you represent, starting with the appellant.
Danielle Quinlan for the appellant, Jennifer Owen.
Peter Hale for the appellee, Town and Country Federal Credit Union.
Thank you. And Ms. Quinlan, if you're ready to proceed, we'd be happy to hear your argument.
May it please the court? Good morning. My name is Danielle Quinlan, and I represent the plaintiff appellant, Jennifer Owen. There are two issues on appeal in this matter. The first issue relates to the court's order on spoliation and granting defendants' requests for attorney's fees related to spoliation. The second relates to the court's erroneous evidentiary rulings on comparator evidence in trial, even after the defendant opened the door on multiple occasions. So I'll take the spoliation issue first. On February 2nd of 2022, the court granted defendants' motion for spoliation related to and provided sanctions in the form of an adverse jury instruction, as well as attorney's fees related to obtaining the discovery at issue, which was the text messages the plaintiff, Jennifer Owen, had exchanged with a coworker, Jessica, formerly Dutton, now Walker. However, at trial, after having the plaintiff go through her testimony and going through the 7,000 text messages that were produced after defendant obtained the phone and downloaded all of the correspondence, the court reversed its earlier ruling on the spoliation issue and found that the text messages in question were innocuous and not relevant or providing any additional information towards any issue that was in controversy or related to the trial. However, the court refused to also reverse its ruling regarding the attorney's fees that it granted to the defendant in relation to the spoliation order for these text messages.
Counsel, I see that the green light is on. You would agree with me, I assume, that in its power to oversee discovery, the court has the power to impose sanctions, including attorney's fees. Do you agree with that?
Absolutely.
And in this case, the motion, I understand your focus on spoliation, but the motion from the defendant was a motion to dismiss sanctions for both spoliation as well as failure to comply with discovery.
My understanding, after reviewing the court's order, was that the order was on defendant's motion to dismiss and for spoliation. It was a motion for motion regarding spoliation and a request that the adverse or the sanction be dismissal of the case in its entirety.
The motion itself, and I'm looking at it at page 47 of the appendix, says it's a motion to dismiss and for sanctions against plaintiff Jennifer Owen for spoliation of evidence and failure to comply with discovery obligations. And in the opening paragraph, it similarly says dismiss and sanction for spoliation of evidence, misleading and or untruthful statements under oath, and failure to comply with discovery obligations. And then when the judge, and so that's why I started off with, you agree that attorney's fees can be imposed as a sanction for discovery problems, correct?
Yes, absolutely.
And then when the judge did the order, which I understand talks about it being a spoliation order, the judge does specifically say that the party was not cooperative in producing records, denied the existence of records, and that as a result, the defendant devoted a great deal of time and energy, which would have been unnecessary if produced in a timely fashion,
that plaintiff needlessly drew out the time and expense of discovery and then imposed sanctions of attorney's fees. That sure sounds like a discovery sanction to me.
Well, it was a sanction related to the spoliation, and I think the specific award was for pursuing text messages, similar discovery-related issues, and discovery related to a third party, Jessica Walker, who plaintiff had no control over, so she should not be paying for defendant's costs for obtaining or pursuing discovery that was in her custody and control.
The sanction was for the effort and the time and the expense that the defendant had to go through in this process, partly occasioned by some of the responses that were received from your client. And at the end of the trial, when Attorney LaRanger asked to have the attorney's fees withdrawn or canceled, the judge was quite clear. No, I'm going to leave it stand because of the discovery violations. Would you agree that we're reviewing this with from an abuse of discretion standard?
Yes.
And as the chief suggested, judges have pretty wide discretion, do they not, in sanctioning for discovery violations?
They do, but only if the defendant can establish that she was withholding probative discovery evidence. These text messages that were obtained, I should give a little more clarity.
The problem, the issue I think for the judge was it took a lot of effort, repeated discovery requests, several requests for production of documents, maybe 2 sets of interrogatories, maybe 2 depositions. This took an extensive effort equals expense on the part of one of the parties. And I think that's how the judge was looking at this.
And how we should have looked at it, in plaintiff appellant's opinion, is that it was really like a dog chasing its own tail. The defense spent a lot of time and their client's money chasing down these text messages that plaintiff had repeatedly said were not about the substance of this case.
But the problem is that the plaintiff also had, in fact, deleted those text messages, and there was some misleading statements about that as well, and whether that had occurred.
She didn't delete the text messages. What happened was she obtained a new phone and gave her old phone to her daughter. She assumed that the text messages would be backed up to the cloud. So it's one of those very...
But you have a finding by the court. It says, the court concludes that Owen intentionally deleted those communications in order to make them unavailable to Town and Country. In doing so, Owen violated her duty to preserve relevant evidence and prejudiced Town and Country's ability to defend the lawsuit. So the court is making an express finding that she did this intentionally to keep it from the other party.
And the only basis for which the court made that decision was that she gave her daughter her phone 4 days after getting the right to sue from the Maine Human Rights Commission. We're talking about somebody who is not...
So are you saying that the court couldn't make that finding? There was not evidence in the record that would allow the court to conclude that she intentionally deleted the communications?
There was no evidence in the record to conclude that. And in fact, the court, upon review and the trial testimony of all the text messages and what happened to our prior text messages, reversed its ruling on the spoliation.
Well, more on the basis that the text messages were actually relatively innocuous, as it turns out, right?
Yes, Miss Walker and Miss Owen, they're good friends. Miss Owen is also Miss Walker's landlord. They live next door to each other. They help take care of each other's kids when one isn't with the other. Most of the text messages were those exchanged between girlfriends.
Okay. Can I go to the other issue about the admission of either comparator or Me Too evidence? What evidence was it that you wished to proffer into the case that established that the defendant does indeed discriminate on account of disability or otherwise treat employees differently on I think it was on a disciplinary issue?
Sure. Miss Walker, formerly Miss Dunton, was also an employee of Town and Country Federal Credit Union.
And was there something that established that in fact she was fired on account of a disability other than her saying so?
She was fired when she was 8 months pregnant, while also had
Is that something, though, that was established, like is it that either the defendant admits or that was established as by a court or something like that?
There was no fine. Sorry, she was 8 months pregnant and had also been recently injured on the job and had a
accepting
number of
those
work
facts.
restrictions. But there was no prior trial. That case settled.
So isn't the judge's view that essentially we'd have to end up having a trial within a trial at that point? Isn't that supported because it wasn't a fact that was otherwise established? It's my understanding the defendant would object or would dispute, rather, that she was fired on account of a disability. I mean, isn't that the very nature of 403 discretion for the judge to exclude that?
Well, I think the issue...
Which might be different had there been like a judgment saying that it happened.
Sure. I think the issue is that we were in trial consistently going through the evidence, the comparator evidence. How were those who were making similar errors to that of the plaintiff being treated when they were called on them? There are those who were not disabled, that were not being terminated, were not being written up for those same errors. There were also those who had medical issues, disabilities going on, that were being written up, disciplined, terminated. Comparator evidence is essential to an employment claim because you're never going to get an admission or the smoking gun evidence that, yeah, we don't want an annoying employee
But this is not a hostile workplace claim. This is a disparate treatment claim. And the predicate for that is that the other employees are similarly situated and treated differently. That is not the case with either of these two witnesses, is it?
It is not that they were similarly situated or treated differently, but with respect to Jess Dutton, Jessica Walker, there was evidence introduced by the defendant. Exhibit 14, it was an interview of one of the branch managers, Karina Rosewell.
Was that given to the jury?
It was given to the jury.
Okay.
And the statement said, well, we never had anybody with performance issues like this except for Jess Dutton, but she was fired too.
Didn't the defendant offer to redact that? And
I believe...
And you elected your client, you elected not to do that.
I believe ultimately the court, after the evidence was already in the record...
Well, no, the document had been admitted, but it hadn't been published to the jury yet.
I think that's correct, but we would have liked to use that evidence to then examine the witnesses, but we're precluded from doing so. Okay. Some of the testimony we would have elicited would have been, isn't it true that when Jess Dutton was terminated for the same performance issues, she was 8 months pregnant and had these work restrictions?
Thank you.
Thank you.
Counsel?
Good morning. May it please the court, my name is Pete Hale and I represent the appellee in this matter. This court will rarely disturb a judgment arising from a jury verdict, especially where that verdict was so rapidly and so decisively reached as in this case, and where the evidence was so strong in favor of the prevailing party. That is because the trial court is in the best position to manage its courtroom and make evidentiary rulings. And to justify disturbing such a verdict, this court must not just disagree with what the trial court ruled on, but this court must find that those rulings exceeded the bounds of the reasonable choices available to it, considering the facts and circumstances. That is the standard. And even if the trial court did make errors, the appellant must show that those errors resulted in substantial injustice or affected substantial rights such that the jury's verdict may have been swayed in appellant's favor. Not only were the trial court's rulings reasonable based on the facts and law available, but they were thoughtful. You can see from the transcript, the trial court tried to be equitable and fair and measured. so as to ensure a fair adjudication of this dispute through trial, despite some unusual happenings in the discovery process. Further, the evidence at trial was so overwhelmingly in favor of appellee, any errors, which we contend there are none, would have had no impact on the jury's findings. Further, under Rule 37, the trial court has broad discretion, as the Chief Justice noted, to award sanctions to a party based on discovery abuses. And the same standard applies, the abuse of discretion standard applies to reverse discovery sanctions. In this case, the financial sanction award was thoughtful, reasonable, and measured, proportional to the discovery abuses, many of which occurred before we'd even discovered that there was destruction of documents. And in fact, related to requests that we had sent to the court for discovery sanctions before we discovered there was destruction of documents. So that fee award was related to the discovery abuses, which the court has broad discretion to grant under Rule 37. It was certainly not beyond the bounds of reasonableness and therefore should stand. Regarding the Me Too evidence that the appellant contends was wrongfully withheld or excluded by the court, this court should affirm the judgment because of three things. One, the court was reasonable in finding that any potential evidence the appellant would have put on regarding Me Too.
Well, I see that the green light is on. Talking about the comparator or Me Too evidence, I mean, isn't that really, in an employment discrimination case, isn't that really critical to talk about when you've got an employer saying, well, really, she wasn't fired because of the reasons you're saying. She was fired because she was a bad employee, I mean, because she made a lot of mistakes. You're entitled to raise that. But aren't they then entitled to show that that's really a pretext, that really was for other reasons? And one of the primary ways of doing that is showing how similarly situated people have been treated by the employer.
That's correct, Your Honor. But what the appellant is doing is conflating comparator evidence with pretext, or with Me Too evidence and comparator evidence. The evidence they proposed putting on with Jessica Dunton and Courtney McNulty are two employees who they contend were also similarly poor performers and were also terminated for poor performance. What you're speaking about, Your Honor, is evidence, and I think it was correctly
Well, I think they're
described
not
by
contending that they were in fact terminated for poor performance. I thought
they are
point
not.
of their right.
They are not contending
they are.
that.
That's why I'm confused.
But the comparator evidence that you're speaking about, Your Honor, are similarly situated employees who engaged in poor performance, who are not in the protected class of the plaintiff, who were not terminated. That is the evidence of pretext that they're talking about, and there was nothing that the trial court did to limit their ability to introduce that evidence.
So are you really arguing more that there really wasn't such evidence, in other words, that it was, they didn't have the specifics of relevant evidence to introduce on that point? I'm not really sure.
They did introduce evidence, or they tried to introduce evidence such as that. For example, if I may, I can give examples. They were allowed to introduce evidence that Betsy St. Pierre had sent confidential information in error to Jessica Walker, but that Betsy St. Pierre was not disciplined for that. They introduced evidence regarding the number of warnings that Karina Rosewell had given to other employees. They introduced evidence regarding whether Betsy St. Pierre had terminated any employees who had only been issued one warning, and in fact asked, was Jessica Dunton one of those employees? So they were not precluded from asking or introducing evidence about employees who had done similar things as Jennifer Owen, but were not fired.
Can I go to the argument about opening the door? The defendant put in two exhibits, Exhibit 14 and Exhibit 36. Both of those exhibits made references to circumstances involving treatment of other employees. Why doesn't that open the door to at least give the plaintiff an opportunity to further explore that through witnesses, not just through closing arguments, but but through examination of witnesses.
Well, Your Honor, I agree that introduction of some evidence to the jury opens the door to something to respond to that evidence. The examples that you provide, Your Honor, Exhibit 14, I think, was rightly acknowledged when appellant was making her argument. The portion of Exhibit 14 that she's referring to was not put to the jury. And so the opening the door doctrine, the idea of that is when one party opens the door by introducing evidence that may mislead the jury, the other party, for the purpose of correcting any attempts to mislead the jury, is allowed to put in rebuttal evidence to correct that, to correct any prejudice.
So the evidence, so Exhibit 14, for example, was admitted, but it had not yet been seen by or published to the jury at that point. Is that correct?
The portion that they are talking about had not been put before the jury at the time appellant's counsel made her offer of proof. So there was no prejudice at that point. And when we identified that issue, we offered to redact it before the exhibit was sent back to the jury during deliberations, and they didn't take that off.
Is that the situation with 36 as well?
36 hadn't, also, the portion they are talking about had not been put to the jury at that time. And what the court did not preclude or deny the appellant from using Exhibit 36. The court actually allowed her to read into evidence the one excerpt from Exhibit 36 she claims was the information opening the door, which I may note, I think contained triple hearsay, not related to the witnesses that we're talking about here, the Me Too witnesses. So there was very little, if any, prejudice involved in those exhibits being admitted into evidence because of the reasons I just described.
Did TNC, as part of its evidence here, attempt to suggest or demonstrate that it's supportive of its employees who have disabilities or conditions?
Town and Country, and just to make clear, in the transcript, what was put into evidence was certain efforts by Town and Country to support cancer research and employees who possibly were going through cancer recovery. That evidence was introduced by Town and Country in response to claims and testimony and evidence presented by the appellant that, one, her supervisor, Karina Rosewell, did not want her to take time off to get what she suspected to be a cancerous lesion inspected, that Heather Savage had discriminatory animus toward her when she terminated her employment, that Betsy St. Pierre had discriminatory animus toward her. And the evidence that we presented was Karina Rosewell raced in the Run for the Cure with Jennifer Owen on her behalf, that Heather Savage had offered items to donate during a bake sale on behalf of Jennifer Owen.
What inference is Town and Country asking the jury to draw from that? What did you want them to think after hearing that evidence?
Well, it goes to motive. It goes to state of mind with respect to Jennifer Owen. She's claiming these individuals had discriminatory animus toward her, yet the evidence shows that they supported her, that they encouraged her, they took time out of their day. And so to the extent that opens...
So we're talking about basically Town and Country's approach, their attitude to these things, and that our attitude was appropriate here, and appropriate there. Doesn't that kick the door open for them to say, well, okay, you did some good stuff there, but we have now a carte blanche to put on contradictory evidence?
I don't agree, Your Honor, that that's carte blanche to put on contradictory evidence. The opening the door doctrine states, you know, to the extent we open the door, that's the only extent to which they get to walk through it. So they were not precluded from asking about evidence or testimony in contradiction to that. And the judge had broad discretion to say, yes, they testified this way, about efforts of specific individuals that they have commented on, like it is the court's, excuse me, Your Honor, the court has broad discretion to say, listen, some of this evidence may have marginal probative value toward what you slightly opened the door to, but I am making the judgment as the trial judge presiding over this case that the threat of prejudice, the confusion, the delay greatly outweighs any probative value of these two former employees and their subjective views over the reasons for their termination. He has broad discretion to make that determination, and he made the correct determination, not just because it would have resulted in a trial within a trial, but because this Me Too evidence, this theory, had not been brought up in discovery. There had been no discovery on it. There were no depositions on it. It involved the very person who was the subject of the spoliation and discovery abuse order, which would have resulted in fundamental unfairness. We would have had to re-litigate the entire spoliation issue, because then if it centered around Me Too evidence over Jessica Dunton, we'd have to look at those text messages again and look at a different view of whether how and to what extent they are relevant, and whether more severe sanctions would have been imposed.
Is it relevant for the employer to say, okay, you're accusing me of discriminatory practices here, but look at these other cases over here where we were not discriminatory, we were very supportive, on the contrary. Is that appropriate evidence to defend the case?
I believe so, Your Honor. I think that is relevant.
So wouldn't it be
in a marginal way, in a disparate treatment case, it is marginally relevant.
The door is slightly open, but not very much?
Slightly. And so slightly does not mean they get to kick it down. It doesn't mean they get to blow the wall apart and send in two witnesses who have allegations and then put on a trial within a trial that would extend the trial schedule another week to, we'd have to reopen discovery.
So your bottom line here is this is a 403 determination?
Absolutely, Your Honor. Well within the court's discretion to say, yes, this evidence might be slightly probative. It may be. It may be slightly probative. But the court is in the best position, the trial court is in the best position to manage its courtroom and to manage the schedule that it has, and to manage the prejudice that would have resulted to the defendant, considering the prior conduct of the appellant regarding Ms. Dunton. And that court was in the best position to say, you know what, I'm making a reasonable determination, and that determination is the jury would be confused, it would prejudice the defendant. This is about Jennifer Owen. This isn't about Jessica Dunton. This isn't about Courtney McNulty. This is about Jennifer Owen.
It's about Town and Country's action taken against Jessica Owen. That's what the case is about, isn't it?
Correct, Your Honor. It was about Town and Country's actions taken against Jennifer Owen, and part of that was evidence that they introduced to try and suggest that Town and Country did not support her, and evidence that one of those events that we're talking about right now was one where Jennifer Owen stood up and said, Town and Country actually does support me and actually has been like family to me.
Thank you, counsel.
Thank you.
Ms. Quinlan?
Thank you. I just wanted to go back to the text messages themselves and the issuance or the granting of attorney's fees. Not only did the court hold that they were innocuous and that they do not go to the merits of the claim, but
And the court did not give a spoliation instruction or permit that inference in the end at the trial.
True. They did not give that adverse inference instruction, but they did approve these attorney's fees, and the attorney's fees included 12.8 hours of reviewing the 700 pages, 7,000 text messages that the defendant wanted. They got what they wanted, and then they got paid for reviewing the text messages that they wanted. If you look through the bill.
So do you want us to take 12.8 hours out?
I think they should all go away because these are text messages like, hey, let's get a bottle of tequila. Let's go do this. Is your daughter sick? Would you like me to get you some Tylenol? A plaintiff should not be punished for not producing private text messages with her girlfriend related to their children, their social activities, not at all related.
Is it unreasonable for the party who had to fight to get this discovery to think, we need to go through this very carefully because it should have been produced the first time around?
I think that's the point. It shouldn't have been produced the first time around or ever.
Oh.
I've never had a case where I've produced thousands of text messages going back and forth about where they're going to go, what they're going to do.
Weren't these text messages requested? Didn't they fall within the scope of the request?
Requested and objected to, and typically what we see is a limitation if they relate to the substance of the lawsuit.
Were they objected to or were they disclaimed? In other words, was there a denial that those texts existed?
There was no denial that they texted each other, that the text messages were going back and forth. There was an objection to the relevance and that there was nothing related to the lawsuit itself.
But the defendant had to go through the effort of making multiple requests and then having the phone ordered produced so the defendant could look at it. I mean, that's sort of an extraordinary step, isn't it?
That's what we're saying. It was so extreme. I mean, the plaintiff wasn't trying to hide it. She gave her entire phone to the defendant.
At the end of the game, at the very end of the process, though, not initially.
Because there was nothing on it. I mean, she gave
She knew that, but the other side didn't know that.
She represented to them in her deposition in response that she didn't have anything that was relevant, and the text messages themselves revealed that she, in fact, had nothing of relevance.
So should the opposing party always be required to simply rely on that representation of what the contents of their phone is?
I think we're all required, unless you have evidence to the contrary, to accept a party's assertion that their production is truthful and honest, and that if they don't have anything that's relevant or related to the request, that's what they're stuck with. I think that's the, if I may have, no.
No, we're really beyond.
Okay.
Thank you. That's why I permitted you to finish your answer. All right, thank you, everybody. Thanks for the arguments in this case. As is our usual practice, we will be taking the matter under advisement and will issue a written decision in due course. And with that, we'll be in recess for the lunch recess.
All rise.